Hello and welcome to The Wire. I'm Sravasti Dasgupta. In August, on the last day of the monsoon session, the Union government presented 3 new bills to replace the criminal laws in the country. These bills were the Bharatiya Nyaya Sanhita bill to replace the Indian Penal Code 1860, the Bharatiya Sakshya Adhiniyam to replace the Indian Evidence Act 1872, and the Bharatiya Nagarik Suraksha Sanhita bill to replace the Criminal Procedure Code, which was in 1973. These bills have now been referred to a parliamentary standing committee and they are expected to come up again for discussion when the committee meets again on the 6th of November. But to discuss these bills and what it really means for our criminal justice system and what the underpinnings of these new bills are, we are being joined on the wire by lawyer G. Mohan Gopal, who is an advocate in the Supreme Court and a renowned legal academician. Welcome to the wire, Mr. Gopal.
Thank you very much, Sravasti.
My first question to you is in your very incisive piece, which you wrote for The Wire, and it is up on our website for our readers to read. You say that the bills only change some 20 to 25% of the law in the 3 current statutes. However, and I'm quoting you here, you also call for close public attention to a dozen chilling changes to the law that have the potential to liquidate liberty, decimate democracy, and fundamentally change the face of our polity from democratic to authoritarian should the government decide to deploy any or all of these changes to the fullest extent. These are strong words you are using, but before we get into any of these chilling changes that you refer to, if you could give our viewers an overview of what you are referring to here and why why the use of such strong words in your piece.
The title to the piece suggests that what the changes the new bills try to do is to establish emergency powers through the criminal law. Now, what are emergency powers? During an emergency, like when the country is at war, the government has vast powers to arrest and detain us, even if we have not committed any crime and we have not engaged in any violent activity. But suppose we say we don't agree with the way the government is fighting the war. That's our opinion, or we disagree with the government's actions in any way, non-violently, peacefully. During an emergency, when the country is at war, for example, the government has a power to come and say, no, you will not say that, and put you in jail, right? Even if you don't commit any crime or engage in any violence. But in normal times, the government can only proceed against us when we do something that's unlawful, including violent acts. Otherwise, we are free to speak as long as we are not, committing a crime, which is actually, which is adopted in accordance with the Constitution within permissible limits. And that's why we say we have the right to freedom subject to reasonable restrictions. Those reasonable restrictions have to be within constitutional bounds and have to be are subject to judicial review. So now what we're going to see is these bills are going to give these emergency kinds of powers where we can be arrested and put in jail, even if we are not doing anything violent, even if we are not committing any offense, because the government doesn't approve of what you're speaking or saying. And so these are in effect emergency powers, but they will be built into the normal law so that these powers can be used by the government, without declaring an emergency. And these kinds of powers to detain people without their having committed any crime or engaged in any violence, simply because of their views and their their beliefs. It goes to the fundamentals of destroying fundamentals of democratic structure and threaten the democracy and freedom in the country.
These are very strong words that you're using there, that these bills kind of build in emergency powers in normal times, which we have not seen before. So if we get down to the chilling changes that you talk about, you write about changes that add new weapons for targeted biased political persecution through prosecution and incarceration of individuals and organizations deemed by the ruling ideologue to be its enemies. Here you talk about laws relating to sedition, terrorism, the UAPA, which is the Unlawful Activities Prevention Act, as well as laws that can be used, laws that actually refer to organized crime but can be used against individuals. If you could take us through these and what you mean exactly by targeted biased political persecution.
Yeah, you see, there is a very well established prohibited use of governmental power, which through selective prosecution, where the government uh, prosecutes someone selectively, motivated by considerations which may be political, which may be corrupt, which may be personal bias, racist bias, gender bias, which should not be taken into account in prosecution. That's called selective prosecution, and that's very well established for many years in our country and in other countries. But what we are seeing is a unique subset of that, which is not fully captured by the intensity and danger of which is not fully captured by simply giving the generic name selective prosecution. That is what I'm calling targeted, biased political persecution through prosecution, right? So we've seen a lot of that going on, that people are targeted for their views and their opinions, and their biases as they see them, and the government is biased against them, and it is political in nature, and it is intended to persecute and not to, and prosecution is used as a method of persecution. So I'm saying we have to recognize in India this unique use of governmental power for TBPP, targeted biased political persecution. And these new changes to the existing laws on terrorism, sedition, and organized crime now free up the government's hands to proceed against people without having to show that they are violating a criminal law or committing a crime, or they are engaging in violence or planning to engage in violence. So the threshold for acting against them has been significantly lowered, so that this persecution that is targeted, biased, and political can be can be easily deployed without legal obstruction. And the courts also will, unless they strike the whole thing down, if this is upheld as constitutional, the courts also will have a very limited capacity to protect people's liberty and freedom when the government does that. Now, we have already special laws on terrorism. It was not defined inside IPC. We have sedition was in IPC. That particular law has been deleted from the Bharatiya Nyaya Sanhita. However, they're bringing what I call sedition plus, which is they're broadening the ability. Sedition was intended to act against people who oppose the government in colonial times, and that was all of our freedom fighters. In fact, it was used against Tilak, it was used against Gandhi, because they opposed the government in order to fight for freedom for the country. But the colonial authorities use that against them. So now the same kind of power is being retained through a new provision in the new bill, which, while formally removing sedition, brings back sedition, the power to move against people simply because they have a different opinion, and they don't like the policies or ideology of the government. It hugely widens that power of the government. Similarly, organized crime. Of course, organized crime is a big danger. We do need to have proper laws on organized crime. We have state level laws, Maharashtra law and Karnataka law called Makoka, Kakoka, and so on. And even if there is a need for a national organized crime, which I would say one could justify, that it should be more in the form of a special national law on organized crime rather than build it into routine day-to-day Indian Penal Code, because these special laws on terrorism and so on, they are already extremely draconian. But there are special courts and some special safeguards and mechanism, minimum as they are, fig leaves as they are, they exist, which will not be available when they're brought under the generic Bharatiya Nyaya Sanhita. So, all in all, as I said, the ability of any government, not just this government. My concern I've expressed in the article is, even if this government changes, future governments are unlikely to roll back these powers. So the people who are now in this government, they themselves may become victims of these extensive draconian powers. So it's unsafe for, regardless of politics, regardless of the ideology, it's very unsafe for us to damage our own democracy in this manner and disable it. Basically, we are making a choice to discard democracy and create a police raj.
Right. We are going to get into the point about police raj in just a moment, but I want to delve into this the expansion of the sedition law, which interestingly I want to tell our viewers that during when the, Amit Shah, Union Home Minister Amit Shah, was introducing these bills in Parliament during the monsoon session, he announced very categorically that sedition has been removed in these new bills. But as you write here, the name sedition might have been removed in the new bills, but it exists in a far more severe form, as you refer to here as Sedition Plus. In addition is the expansion of the UAPA laws. Now, this is of considerable interest to our viewers, as we see every day there are increasing attacks on political parties that are in the opposition, of political leaders, of dissenters, activists, human rights workers, etc. So, if you could explain to our viewers a little bit about how this UAPA is being expanded and sedition is becoming Sedition Plus, which could endanger our democracy.
Sure. If you look at Section 124A of the Indian Penal Code, which is sedition, which has been removed, the Union Home Minister is correct that that section is gone. That section basically criminalizes the creation of 5 sets of negative attitudes towards the government. This is a colonial provision: hatred for the government, contempt for the government, disaffection for the government, disloyalty and enmity towards the government, with some with some clarification that this will not apply to mere criticism of administrative actions and so on. But what does the new Sedition Plus law do? It's a proposed clause 150 of the Bharatiya Nyaya Sanhita. The name of the offense is acts endangering sovereignty, unity, and integrity of India. And what does it criminalize? It criminalizes subversive activities, secession, right? Separatist activities, endangering sovereignty, unity, and integrity of India, and armed rebellion. Now, none of them is statutorily defined. So if you want to get someone for hatred for the government, contempt for the government, disaffection, disloyalty, enmity for the government, then you can still get them for saying that you're engaging in subversive activities, right? Because of the attitudes that you have, what you're doing is subversive against the government, or you are being secessionist or separatist, or you're endangering the sovereignty, unity, and integrity of India. So people who are against the government or the ideology of the government, or even who wish to see, like you take the Sangh Parivar, for all these years they've been able to canvass for establishing a Hindu Rashtra, which is completely in conflict with the constitutional, secular, democratic, socialist republic that we have, because that was permitted by the Constitution. This was not seen as prosecutable, although it did involve hatred and contempt and disaffection and disloyalty and enmity towards the republic. But it was we all wanted that kind of ability to prosecute challenges to the government and governmental structure removed from the penal law by deleting the sedition law. What we now have is that the ability to prosecute people for questioning the government, opposing the government, has been brought back in the form of subversive activities, in the form of separatist activities, or in the form of endangering the unity and integrity of India. That's been misused a lot. If you speak up for a group against a strong and powerful oppressor group, that is seen as endangering the unity and integrity of India. And so if you speak up against the caste system on behalf of the exploited, the excluded classes and castes, then you are seen as dividing the country on caste lines and threatening the unity of the system, because you're demanding equality and you're demanding an end to exploitation and expression, similar exploitation and oppression. Likewise, if you are fighting against patriarchy, you can be accused of threatening the unity of society by raising issues of women's rights and so on. So what we wanted was that sedition should be removed so that people will have the freedom in the larger interests of the people of the country to fight for the core values of the of our democratic, secular, socialist republic. When the government moves against it, not to have an even wider range of offenses that can act against dissent and can act against disagreement and opposition to
Right.
the government.
That's a very important point you're making there, that the idea was to have sedition removed, but on the other hand, we've got a even wider range of activities, subversive activities, as you refer to in the new bills, that could, in a sense, endanger any activity that goes against a particular ideologue's idea of how things should be. But what you also interestingly write about is that the bills kind of give legislative power to facilitate the Sangh Parivar's work against democracy. If you could explain what this means, and what do you see in the provisions in the new bills that have led you to say so?
Yeah, and before I turn to that, I just want to quickly mention that the problem we have in the Sedition Plus is that these terms that have been brought into clause 150, which I referred to, are not defined, and there are also no established there's no interpretation of 150 to fall back upon. Whereas in sedition, we have, from the sedition trial of Mahatma Gandhi more than a century ago, we have a strong tradition of how to interpret it in a narrow way so that we preserve democracy. So we're bringing in Sedition Plus a new set of terms which have not been interpreted, and that can be used very widely against us. Now let me turn to the question you asked about the provisions that could protect those who are seeking to establish a theocratic Hindu Rashtra on the country. The definition of terrorism that has been brought into the Bharatiya Nyaya Sanhita is very different from the definition of terrorism that exists under UAPA. And it seems to borrow from the European definition of terrorism, which is subject to several constraints, but without those constraints, which say that terrorism is an attack on a serious attack on the fundamental structures which are social, political, and constitutional of the country. Now, when the Bharatiya Nyaya Sanhita takes this definition and makes it terrorism, very interestingly, it omits the need for the attacks to be serious. It omits the need for the structures that are attacked to be fundamental in nature. But it retains in it the definition that you cannot attack the social structure of the country without the qualification of fundamental and serious. And of course, in Europe, what they're talking about as a social structure is a social structure that has come out of civil wars and reform and revolutions, and so they have an egalitarian social structure, and so they do not want a regressive attack on an egalitarian social structure, at least in form, if not in substance, based on equality, liberty, dignity, and so on. But here they've taken the social structure, and in our country, the social structure remains extremely regressive based on caste and patriarchy. And so now they've made it a terrorist attempt to engage in non-violent, peaceful, non-criminal acts that they will consider to be an attack on the social structure, that will therefore enable them to, as I said earlier, to say that potentially say, if they wish, that an attack on the caste structure or on patriarchy is an attack on the social structure, and therefore it's a terrorist act. Interestingly also, although the European definition refers to an attack on the constitutional structure, our constitution is also an egalitarian constitution like the Western constitutions. And so any attack on our constitutional structure should be seen as very serious, as the Europeans do. But very interestingly, the Bharatiya Nyaya Sanhita definition removes the attack on constitutional structure from the definition of terrorism, which the Europeans include. So they retain the social structure to protect not an egalitarian but a regressive social structure from change, and they remove the definition. They remove the attack on the egalitarian constitutional structure as a terrorist offense, which the Europeans include. So that they are free to attack the constitutional structure without being caught up in that accusation of being a terrorist in their own enlarged definition of terrorism. Of course, I personally believe that, of course, in the European context, these attacks have to be violent. They have to be crimes under established law, and they have to involve violence, not simply expressions of opinion, non-violent, peaceful expressions of opinion. So when you take all this together, it becomes a very serious restraint and constraint on pursuing the kind of progressive egalitarian change that, for example, in Kerala, Narayana Guru fought for 100 years ago, right, to bring about an egalitarian society. If he were alive today, he may have faced prosecution for terrorism.
Right. So these are very small changes which one can only identify if one reads these provisions very closely, as you have done, and you're bringing it to the attention of our viewers. And I also want to draw your attention and the viewers' attention to the part in the piece where you speak about how these laws in effect enhance police raj in the country. Now this, you say, takes place through maximizing police custody, the powers of arrest, and bringing back handcuffing, among others. If you could take our viewers through this and why you view this to be problematic.
Before I do that, can I again, in 30 seconds, simply mention that another interesting and important change in the new bills is that there was in 2005 the introduction of an offense to conduct mass drills with arms that included lathis. This was brought into the Indian Penal Code, and a corresponding provision was put into the Criminal Procedure Code, which somehow even the Congress government never brought into effect. But it remained a crime in the Indian Penal Code, which had not been notified. That's all it had to be done. So it was under that provision, once notified, it would have been a crime to engage in training or mass drills using lathis or other weapons. This very important provision in the realities of the ground realities of our country has been removed from these bills. They've disappeared, so that it's now possible for those who wish to do it to engage in this training. Of course, if the wrong people do it, there are many other laws that can now be used to stop them. But if the right, quote unquote, right people engage in armed drills and training, then there is no specific provision to constrain them. That's another change that I see as being very helpful to the Sangh Parivar and forces who include armed with lathis training as part of their normal training and drills. Now let me turn to the police Raj question that you asked. In a very broad draconian provision that has been included as clause 172 is that all persons shall be bound to conform to the lawful directions of a police officer given in fulfillment of any of his duties. Now, there are already provisions in the Indian Penal Code, well-established provisions about not following the instructions of public servants generally, not just police officers, but public servants, generally officials of the government, and punishment and penal consequences for not doing so. There's a well-established mechanism. Now suddenly we see a special law simply saying that you have to obey the police. You have to obey the police. And it says that a police officer may detain or remove any person resisting, refusing, ignoring, or disregarding to conform. That's the language they use, to conform to any direction given by him. and may either take such a person before a judicial magistrate or in petty cases release him when the occasion is past. So very special powers being given to the police to issue orders and then arrest you if you don't listen to them, which normally should have been done. Really, there are provisions in police acts also that give these powers, and we've been resisting those powers. So rather than removing them and bringing them subject to accountability and subject to close scrutiny, we are enlarging these powers, and the impact at the ground level, I think, will be not very good for us. And handcuffing, the Justice Krishnaiyer in two very important judgments in the Supreme Court in 1978 and 1980, I believe it is, Sunil Batra and Prem Shankar Shukla had very movingly said that to bind a man hand and foot, fetter his limbs with hoops of steel, shuffle him along in the streets and stand him for hours in the courts is to torture him, defile his dignity, vulgarize society, and foul the soul of our constitutional culture. He spoke very strongly. That was a long, nearly about over 40 years ago, and it's taken maybe even half a century to even get this very strong language of the Supreme Court to affect the behavior of the police on the ground. And we are just struggling to make progress in that, when now the new CRPC, the Nagarik Suraksha Sanhita, has provided a list of laws on which the police may use handcuffs. That is giving them a license to use handcuffs in those specific statutes, and that will then lead to reinforcing the culture of using handcuffing as a means of humiliation, as a means of asserting power, and also corruption. To say, look, if you on the ground, there will be an industry to bribe a policeman not to handcuff you in front of your of your community and society for accusations which may have no basis at all, and also to inflict pain and suffering on people. So generally punishment has been increased. Punishment before you're convicted and after you're convicted have been increased. And so there is, I think, the concern we've all had for years, where, with this very poorly implemented, inhumane criminal law in our country, is that the process has become the punishment, and that's becoming worse now rather than improving it. There's not a single strand of a pro-people, liberal, democratic change in these bills. And as we know well, colonial law has a democratic content. Had the colonial law we had some modern content. Scholars have recognized that. Rule of law content, constitutionalism content, even within the framework of colonial law, in the limits of colonial law. But it had a huge amount of pure brutality, as all colonial, and including the British regimes were brutal. And so it had a huge amount of brutality. That brutality has been reinforced and strengthened, and we've lost a very important opportunity to bring in some humanity into criminal justice.
It's very interesting that you're saying that we've lost an opportunity to bring in any humanity in the criminal justice system, because interestingly, I just want to mention again for our viewers that when Mr. Amit Shah was introducing these bills in Parliament, he said that one of the objectives behind rehauling the criminal laws in the country was to, of course, shed India's colonial past. And the second thing that he highlighted was to make reform the objective of these new laws and not punishment. The idea was on rehabilitation. The focus was on rehabilitation and not on punishment. But as you're trying to draw our attention right now, it appears that the brutality has kind of been retained in these new laws. So I want to just build on that and ask you that since these bills kind of present an opportunity for us to relook at our criminal justice system, these bills are with the committee at the moment, and they are consulting domain experts as well well as members of parliament on how it should go forward. In your opinion, does this present an opportunity to rehaul our criminal justice system for the better? And if it is so, how do you foresee that?
No, I think there's no doubt that we've all been struggling with, from a constitutional law point of view, to bring in the ideals of the Constitution into criminal justice and police administration, with very little success over all these years. The Law Commission has made many reports, many commissions. Recently, the J.S. Verma Commission, the late Honorable former Chief Justice of India, Justice J.S. Verma, he had given, after the awful, brutal rape and murder of Nirbhaya, that committee was appointed, and they had made certain provisions, recommendations on how to improve the criminal justice system. All those have been ignored. But I think the Home Minister is not wrong when he says the purpose is not to give punishment, but to give justice, because the question is, whose concept of justice? Whose concept of justice is the question? It is not the constitutional concept of justice he was referring to. And why should he? He is speaking on behalf of the Rashtriya Swayamsevak Sangh, that believes that our idea of justice should be Vedic idea of justice, right? Should be a Varnashrama idea of justice. And that justice should be enforced in the brutal ways in which it was enforced for centuries, which continued even under colonial times. And it was only a breath of fresh air came in only with Dr. Ambedkar's constitution into this landscape. So yes, he feels that he wants to raise conviction rates to 90% when we know that police is corrupt and investigation is completely shot through with lack of integrity. We want conviction rates to be increased to 90%. He says the idea is not punishment but justice, and that justice is dand. Dand is justice, right? So what we want is not that the kind of justice that the ideology that he represents demands. We want the kind of justice. I referred to Narayana Guru earlier, where he said, we should have the compassion not to cause pain even to an ant. He used to say that we should always work for the happiness of others. He talked of compassion, right? That's the kind of justice we have to build into, that is in the Constitution and should be built into our criminal justice system, not this kind of justice.
All right, those are very interesting insights that you have given us to our viewers, and I would urge our viewers to head on to thewire.com and read this article which is up on our website to gain further insights into how these new bills really build in emergency provisions, as Mr. Gopal is saying, in normal times, which can harbor very dangerous times for our democracy. Thank you so much, sir, for joining us on The Wire, and thank you to our viewers for watching.
Thank you so much, Sravasti.
द वायर के और वीडियोस देखने के लिए सब्सक्राइब करें और बेल आइकन पर क्लिक करें। स्वतंत्र पत्रकारिता की आर्थिक मदद करने के लिए डिस्क्रिप्शन में दिए गए लिंक पर जाएं और अपनी राशि चुनें।